Good morning. This is the first day of the hearing in the case of Re T. As the issues in relation to this case arose in relation to a child, there will be reporting restrictions. We make an order that no one shall publish or reveal the name or address of the appellant who's the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the appellant or of any member of her family in connection with these proceedings. It's possible to find a copy of that order on the Supreme Court website, along with the case details. It's going to be posted shortly. T, the appellant, is represented by Mr. Toomey, QC, together with other counsel, and I'm going to turn to him now to open the case, please.
I'm grateful. May it please your lady, my ladies, my lords. I appear on behalf of the appellant together with Mr. Leng, Ms. Cooper, and Dr. George. The court, I hope, has received a full list of the various parties, interveners and counsel appearing in this matter, both through written and oral submissions. There is one preliminary matter in respect of the witness statements in Appendix 2 from electronic number 774 onwards. I don't wish to use up much of the court's time on this. I note that no party objects to the local authority adducing the witness statement of Mr. Jenkins, dated the 30th of September, or to the appellant adducing her short 16th of October witness statement in response, which is at EF 810 onwards. My ladies, my lords, this case was said by the Court of Appeal to be about the inherent jurisdiction authorising the placement of a child in the equivalent of secure accommodation. There is, in fact, we submit, no equivalence in the treatment of children who are confined, ostensibly for the purpose of educational supervision in homes, without the protection of the court being satisfied that the strict and clear criteria of the statute are satisfied before their liberty is restricted, namely Section 25 of the Children Act, without the protection of the secure accommodation regulations made under that Act, including in particular without the protection of the approval of that home to be used as a secure home by the Secretary of State. And without that, which comes with that approval, we say there's a plethora of significant further essential protections, twice yearly inspections of the secure home by a dedicated Ofsted team, inspections carried out according to a separate secure children's homes framework designed to meet the increased vulnerability of children in secure settings, and regular visits of those homes by the National Preventative Mechanism as part of its obligation to inspect places of detention in order to prevent torture and other ill treatment. That is the position where, as with the second order under appeal, the accommodation in which this appellant was placed was a registered children's home. Where, as in the case of accommodation approved by the first order under appeal, the home is not registered as a children's home, the situation is entirely unregulated, and consequently, for a young person such as this appellant, it is, we say, markedly worse. In particular, the child is placed without any of the protections of the children's homes regulations. And mere consideration of the depth and the breadth of those regulations demonstrates beyond doubt the significant disadvantages suffered by a child confined in such accommodation. Of particular importance, having regard to Article 5, which is considered to be, with Articles 2, 3 and 4, in the first rank of the fundamental rights that protect the physical security of the individual, are the essential protections guaranteed by the Children's Homes regulations. So in particular, as to education, physical restraint, and the bona fides of those operating and working in those homes. So to regard placement in an unregulated home as coming close to an equivalence with approved, secure children's homes is simply wrong. And it's perhaps unsurprising that in this particular case, on its own case, the local authority has, as regards the first unregulated placement, they had concerns about the placement's ability to meet the basic needs of the appellant. And they refer to boundaries, structures, routines, and preparation for her independence, all arising within a few weeks of court authorising her confinement there. So perhaps even more concerning, the court, acting under its inherent jurisdiction and applying a welfare best interest test as its paramount concern, endorsed the appellant's confinement in that placement for at least another 5 months. The case is, therefore, for the first time, and with this court's leave, about whether the inherent jurisdiction can be used to bypass the statutory scheme set out in the Act and the regulations to do that which Parliament has expressly said should not be done. It's about the Secretary of State, pursuant to his statutory power, prohibiting the restriction of children's liberty in children's homes, which are not approved for that purpose, and yet intervening in this appeal to say that the prohibition can be ignored by the use of the inherent jurisdiction.
Can I just ask you to pause for a moment, Mr. Toomey, because that takes us into one of the concerns which we have got about the fact that the appeal is proceeding on a basis which was not done in the courts below. And so there are no findings to tell us the nature of each of those two placements in which T found herself. Our concern is that ground one may look different depending on whether the accommodation in which she was, those two placements, was secure accommodation apart from the fact that it wasn't approved by the Secretary of State for that purpose, or wasn't within that category at all. So how are we to proceed in the absence of findings of fact?
Well, I think I think what I can say is that the judgment of the court, first instance, we say, puts the matter beyond doubt. So perhaps I can deal with that part of the judgment. So I think in that
before you go on to that, it isn't agreed, is it, as to the status of those two placements? It's not common ground.
I think it's common ground that the second one was a children's home, but not approved. And I think it's common.
But was it otherwise within the definition? Is it agreed that it was otherwise within the definition of secure accommodation?
Well, that's how the judge treated it.
Right. Okay.
Because
yeah.
So, and in fact, in respect of both accommodations, the judge treated the alternatives to approved children's homes, secure homes. So both the first and the second placement, the judge treated them as secure home, as secure accommodation. And we can see that in his judgment, and we can see that in the orders made pursuant to his judgment. The issue that I think does exist potentially is as to the nature of the first placement and whether that constitutes a children's home. There's common ground between us and Kafkas Cymru and the Welsh government that it does. The intervention by the Children's Commissioner says it must do. The local authorities don't appear to agree that, but I'm not clear why that's not agreed from their case. And the Secretary of State draws attention to the lack of agreement. But
there are various possibilities of what we can do in those circumstances. One is that we have to proceed on a basis, a hypothesis, an assumption.
Yes.
And it would be useful to know whether there is any agreement between you as to how we can narrow down what would otherwise be an unresolved factual issue.
Thank you. Well, that's not something that we have between us agreed, but I hope with my lady's helpful indication that is something we can agree. I mean, certainly what I would say is that in relation to the first placement, whatever it was not approved by the Secretary of State, and it was not regulated in any way. So it fell outside of the children's homes regulations. Whether it should or it shouldn't might be a contentious point. If we could proceed on the basis that insofar as the second placement is concerned, it was an unapproved children's home, but that otherwise met the definition of secure accommodation, and that in the first place it met the definition of secure accommodation and it was not regulated, that we, Welsh Government and Kafkas Cymru at the moment say it was a children's home that is not yet agreed, but we will seek the agreement of the other parties, particularly the local authority, to see if this case can be decided on the basis that it should be treated as having been a children's home.
Yeah.
Lady, I'm very grateful. Clearly, we then go on to refer to the application when looking at ground 1 of section 102D. And we say there's no doubt that the orders under appeal in this case, but for those, the local authority was unable to confine the appellant. And so the powers to determine the questions as to whether she was to be confined, how and for how long, were all conferred on the local authority. Excuse me, the orders themselves do not confine the appellant. They confer the power on the local authority. And so really by way of introduction, my ladies, my lords, we say that this is a very serious case. It applies to the most vulnerable children in our society, those who need to be confined for their own protection. And it's about whether in unapproved children's homes, the different jurisprudence under the inherent jurisdiction has led to an inaccessible, imprecise, or non-foreseeable scheme without definitive criteria for its use. But importantly for this appellant, I should say that from the date of the hearing when she was 15, and a Gillick competent 15-year-old at that, the case has always been about recognition and appreciation of her consent as valid, valuable, and something to be part of the evaluation of the court. And so we say it does provide the court with a good opportunity to address address the issue in relation to two schemes: registered children's homes which are not approved and those where they are wholly unregulated. We're going to invite the court to consider significantly limiting this practice, and as part of that, we say that Section 25 is sufficiently broad so as not to leave any vulnerable children falling through the cracks. And in fact, the view that the alternative, the so-called equivalent of secure accommodation, is what gives rise to the risk of children falling through the cracks, because it is not equivalent. Ladies and lords, I think you have the history, so I won't fill out in any great detail. Safe to say the first placement was from July 2017 in London, and that continued until March of 2018, when it broke down. The appellant was moved to Derby, and there she remained for the region of about 18 months. So with your leave, then I'll move to address, first of all, ground 1, and in particular, if I may, address what we say in respect of section 102D of the Children Act. And that can be found at electronic EF 869. I'm going to give the EF numbers unless any other terminology is preferred. And we see there the restriction on the use of wardship, as it's entitled. And we are concerned with 2D, for the purpose, no court shall exercise the High Court's inherent jurisdiction with respect to children for the purpose of conferring on any local authority the power to determine any question which has arisen or which may arise in connection with any aspect of parental responsibility for a child. It's one of 4, as we can see, arising 4 prohibitions under subsection 2, and there they are set out, A, B, C, and D. If none of those bars applies, then a local authority can seek to invoke the court's inherent jurisdiction, but only by first obtaining the leave of the court, and leave will not be granted unless the order sought can't be obtained by any other means under the Act. And if the order is not granted, there are reasonable grounds to believe the child is likely to suffer significant harm. We see that in subsection 4A and B. And so we say it's important to regard each of those subparagraphs of 102 independently, not to conflate them, and as having a different purpose. And may I begin my submissions on this ground by asking the court to consider how the court has necessarily approached a different part of 102, and that is 102B, and to ask the
Can I
court to
just ask
consider.
you to pause for one moment because we've lost Mr. Hopkins for, I'm not sure whether he's completely cut off.
No, my lord, my lady,
Yes.
I can hear.
You can hear. Are you happy to
Yes,
carry
my
on?
lady, my lady.
Okay, thank you very much.
Yes, thank you.
Thank you. Can I ask the court to consider the case of A, City Council, and LS and others, and that's to be found at page 2601, which is the decision of Mr. Justice MacDonald. And the question that the judge faced in that case appears at 2603, at paragraph 1 of his judgment. Does the High Court have the power under its inherent jurisdiction upon the application of a local authority to authorise the placement in secure accommodation of a 17-year-old child who's not looked after by that authority within the meaning of the Act, whose parent objects to that course of action, but who is demonstrably at grave risk of serious and possibly fatal harm? And he was satisfied, the answer was no. And this was because the child was not looked after. The order would have had the effect of authorising removal from the mother's care without her consent in circumstances where she had exclusive parental responsibility. And so it was held that this course of action was prohibited by section 102B. And we see that in his judgment at paragraph 48, which is at 2616. And there he sets out how the course of action proposed is prohibited by the statute. But it's important, we submit, to just look at what was argued on behalf of the local authority in that case. And at 2608, one can see what counsel for the local authority was inviting the court to do at paragraphs 23 and 24. Counsel submitted, that's 2608, that the orders he seeks do not contravene section 102, as such orders would not require the local authority to accommodate the young person, but simply authorise such accommodation. He argued that in circumstances where the statutory regime does not provide a remedy for the grave risk to KS's welfare, he contended for the local authority, by reason of his not being looked after for the purposes of section 25 of the Children Act, a statutory lacuna existed. And so he sought to invoke the court's inherent jurisdiction to deal with what he said was a lacuna. He relied on the evidence before the court that demonstrated the risk of harm was extremely high, and in the circumstances there was reasonable cause to believe the court's inherent jurisdiction, if not exercised, would lead him to suffer significant harm. And we say the judge correctly relied upon the statutory bar to refuse the remedy sought. So this demonstrates that these statutory bars may prevent the court exercising a protective jurisdiction in respect of minors, notwithstanding potentially very serious consequences. And we say the reason for that is set out again in this judgment, and we see it at 2617, where Mr. Justice MacDonald refers to the constitutional concerns at paragraph 53, where he quotes from a judgment to Mr. Justice Hayden in Redbridge, London Borough Council in A, the High Court's inherent powers are limited both by the constitutional role of the court and by its institutional capacity. The principle of separation of powers confers the remit of economic and social policy on the legislature and on the executive, not on the judiciary. It follows that the inherent jurisdiction cannot be regarded as a lawless void permitting judges to do whatever we consider to be right for children or the vulnerable, be that in a particular case, more generally, as contended from here, towards unspecified categories of children or vulnerable adults. And so back to section 102D, we say it's important not to confuse and conflate two distinct concepts, One, the exercise of parental responsibility by a local authority under a care order. And two, the power to determine any question in connection with any aspect of parental responsibility. We submit that the Secretary of State's case confuses and conflates these two distinct concepts. There is a distinction between a local authority exercising parental responsibility and seeking an order giving it authority to determine a question in connection with an aspect of the exercise of parental responsibility. So there's no dispute as between the parties to this appeal. The local authority had to seek an order from the court as it lacked the power to confine the appellant. At the very least, it could not, as an emanation of the state, provide its consent for the purposes of Article 5. And we say that must be right. And so it follows that but for the court application, the local authority could not confine the appellant. So that means that the order of court was conferring something on the local authority. So this is now quite different to the cases such as medical cases. And we address that in our written case at paragraph 40. But can I ask my ladies and my lords to look, although not a medical case, at the issue of local authority parental responsibility. It's what I would call a naming case where proposed names for a child or children were so dreadful as to be harmful for those children. That's the case, the judgment of Lady Justice King in, I'll give you the references, I hope, 3166. So it's Re C. I'm taking you by 3166 to the part of the judgment I'd like to refer to first, if I may. And perhaps I can, go back to 3165 about the powers of the local authority when a care order is made, at paragraph 61. Whereas a care order in place, the power conferred upon a local authority by section 33(3)(b) excludes certain circumstances where Parliament is of the view the issue in question is too significant to be determined without either consent or a court order, and those are set out. So those, for example, include not to raise the child in religion other than the child's natural religion. But setting a name is not within that, and so that led at paragraph 66 the judge to say that the local authority had, on a strict reading of section 33(3), the power to do exactly as they proposed. And then turning on, if we may, to paragraph 90 at the bottom of 3170, Lady Justice King refers to the medical cases. Whilst I may not necessarily agree with the precise way the jurisdictional issues have been approached or expressed in these very difficult cases, what's clear is there is a cohort of cases where the common theme is that a party, be it a local authority or an NHS trust, has sought to bring an issue before the court, believing it to be of too great a magnitude to be determined without the guidance of the court. 91, most commonly the medical cases, where a declaration is sought in the face of a parental refusal to consent. And at 93, in my view, whilst the local authority were wrong in concluding they had insufficient authority to consent to the course of action proposed by the NHS Trust in the case referred to above, Re B, given their powers under section 33, they were undoubtedly right to have brought the matter back to the court. So the power conferred on the local authority in this case is distinguished by virtue of the fact that it was provided under the court order granted at first instance it was provided with a discretion as to whether, how, and in what circumstances, and in what and to what extent it should confine the appellant. And so that's why we say the law is right as it stands in relation to whether a parent may give a valid consent to the confinement of their child, as set out in our written case at paragraphs 54 to 59, electronic pages 185 to 186. And there we in particular draw the court's attention to the position at paragraph 59 that the current law is as follows. In law, it is possible, this is EF 187, it is possible for a child with a requisite understanding of the issues to consent to living arrangements which otherwise amount to a deprivation of liberty. The consent to living arrangements for a child under the age of 16 can be satisfied by the substituted consent of a parent. And in particular, we refer to, in Re D, the dissenting judgment of Lord Carnworth, with whom Lord Lloyd Jones agreed, regarding Mr. Justice Kean's analysis of parental responsibility in the case when the child was 15, reported at, or to be found at electronic page 3198, where he sets out the approach to parental responsibility, which we say, I think it's paragraph 57 and following, is correct. And that is the approach that Sir James Mumby adopted in the Court of Appeal in Re D. So we can see that set out at page 3211. Mr. Justice Kean's analysis. And perhaps I should just draw direct attention to paragraphs 56 and 57, not least because the ages referred to there include, in both cases, a child of 15, very different between a 5-year-old and a 15-year-old. And at 57, the decisions which might be said to come within the zone of parental responsibility for a 15-year-old who does not suffer from the conditions with which D has been diagnosed will be of a wholly different order from those decisions which have to be taken by parents whose 15-year-old son suffers with D's disabilities. So whilst we accept there are a number of uncertainties in law about precisely what a parent can and cannot do under her parental responsibility for a child of the appellant's age at the time of these orders, it is within the scope or zone of what a parent can do, depending on the particular circumstances of that child. Deciding whether, and if so, how to confine the child is therefore objectively and clearly in connection with parental responsibility. And if the confinement under Article 5 is for the aim of educational supervision, that is within the ambit of typical parental responsibility, for which the holder of parental responsibility has been unable to bring about. Once the order of the court gives the local authority the power to decide whether and how to confine, that authority has had conferred on it the power to determine a question arising in connection with an aspect of parental responsibility for the subject child. So we say there is otherwise in the Secretary of State's case confusion between the two concepts, leading to his argument that the authorization of detention type accommodation is an exercise of parental responsibility which has already been granted by the care order. It isn't, because the local authority's parental responsibility under a care order does not extend to making a decision about the detention or authorizing the detention of a child in accommodation provided for the purposes of restricting liberty. Indeed, the local authority does not propose that it can do so off its own bat, and that's why it made an application to the court. And so it's important, we say, to note what the court enabled the local authority to do. It operates at discretion as to whether or not to place the child in the accommodation is identified as restricting liberty, pursuant to the court's permission. If it does place the child, it operates an ongoing discretion as to the extent to which the restrictive features of the child's care are extended or lessened. It operates a discretion as to when to review the applicable measures. It operates a discretion as to how to review those measures. It operates a discretion as to when to bring those measures to an end. And each one of those discretions was conferred on this local authority when the two primary orders under appeal were made. And that's summarized neatly in the Court of Appeal's judgment, I should say, at paragraph 85, where one can see, and this is electronic page 770, the court says this about the consequences of the orders. It's paragraph 85. at 770. Once the court has authorised placement in secure accommodation or its equivalent, it may properly be considered that the matter can be left to those who are authorised to operate the care regime on a day-to-day basis, as in the present case, they may work with the young person in a flexible manner, using their powers of restriction or deprivation when necessary, so in their opinion, but relaxing them when it is safe and appropriate, say in their opinion, to do so. Having regard to the power to determine any question in connection with any aspect of parental responsibility, as opposed to the exercise of parental responsibility by a local authority under a care order, the meaning of to determine is not the same as to exercise. In the Oxford English Dictionary, to determine is to cause something to occur in a particular way, or to ascertain or establish exactly. The court, in each order under appeal, gave the local authority to determine the particular way in which the appellant could be confined. Not only did the local authority not have the power, but the order did not confine the appellant, it delegated to the local authority whether and to what extent the power should be exercised. The purpose of section 102D is to prevent the inherent jurisdiction from being used to allow local authorities to determine any parental responsibility questions they don't already have under their remit. It's a statutory body and its powers are conferred by statute. And of course, that phrase is replicated in Section 8 of the Children Act, which deals with the private law sphere. And my ladies, laws will note that by Section 9, that route is not available to a local authority because no court shall exercise its powers to make a specific issue order in any way which is denied to the High Court by Section 102 in the exercise of its inherent jurisdiction. So this reflects an important point in the scheme of the Act. The local authority is forbidden from having a specific issue order or prohibited steps order in any way that's denied by Section 102 in respect of its inherent jurisdiction, or the inherent jurisdiction, and having any relevant Section 8 order if the child is in its care. So it'd be curious if these bars at the heart of the Children Act could simply be avoided by recourse to the inherent jurisdiction. What we say does matter is that confinement is in the locker, so to speak, of parental responsibility. The locker cannot be opened by the local authority, notwithstanding the fact that it has parental responsibility. The local authority needs the court to avail of that power of confinement. The court confers the power on the local authority. Whether or not it's available to any other holder of parental responsibility, such as a parent, to exercise that power for that particular child does not matter. What matters is that the local authority is now able to do something it could not before conferral do, and which it now does at its discretion. We say then there's a second reason as to why there's a conferral of power on the local authority, and that depends on the particular circumstances of the child. For the reasons we've set out, our primary submission, it doesn't matter whether or not the child's confinement is permissible at common law. The point at which the theoretical right of the parent to restrict the liberty of the child might cease at a number of points. We think maybe three: the age of capacity, which was the approach of the former President James Mumby in the Court of Appeal in Reedy, which was endorsed by Lords Carnworth and Lloyd James in the Supreme Court decision in Reedy. The age of discretion, according to common law, expressly endorsed by Lady Black when considering children aged 16 or 17, but leaving open consideration of the Gillick issue for children under 16. And 16 years of age in the case of a child lacking capacity, contemplated again by Lady Black. The Secretary of State's case is clear at paragraph 76, 362. A parent cannot confine a child who is Gillick competent, says the Secretary of State, and he uses the phrase, it is not part of parental responsibility to confine a Gillick competent child. If the Secretary of State is correct, that a Gillick competent child cannot be confined, then we say it's all the clearer that the court permitting a local authority to confine that child is providing the local authority with something it otherwise lacked. It's a power over the child it could not previously exercise. So for yet another reason, the court's order in such a case is conferring on the recipient authority a power to do something, the power relating to confinement. The nuts and bolts of the decision have been left to the local authority. Undoubtedly, those new powers relating to confinement are then employed by the local authority as part of its parental responsibility over this Gillick child. The local authority is then being put in the position of being able to confine a child in exactly the same way that Key and J envisaged a permissible exercise of parental responsibility in the case of, for example, a 15-year-old lacking capacity, or as Victorian cases envisaged, a father restricting his child's liberty prior to the age of discretion. The local authority is undoubtedly, in that case, determining issues in connection with parental responsibility. And then the third reason we rely on, and this I will develop in due course when I come to ask the court to consider the effect of Section 25. But in brief, the third point is that the common law, whatever it may be, in relation to children under 16, is subject to the effect of Section 25 and the regulations made thereunder. Where the scheme applies in England, Wales, Parliament has limited the ambit of the local authority's powers, where those powers are derived from its parental responsibility for the child or its statutory power under Section 3(5) of the Children Act to do what is reasonable to safeguard and promote a child's welfare. The effect of Section 25 is that whatever may have been the local authority's power to restrict, which depends upon whether it has parental responsibility or the Section 3(5) power, those powers are restricted where Section 25 applies. So if Section 25 applies, and that's I'll return to, if I may, under grounds 1B and C, the court is being asked to provide powers which have been taken away by statute, and therefore necessarily is investing in the local authority the power to determine the question which has arisen or which may arise in connection with the aspect of parental responsibility. Lady.
Can I just see where this goes? If we follow through your submission, it doesn't just apply to the sphere of the Section 25. If you've got a child that needs to be restrained in some way, to the extent of it being a deprivation of liberty, given the age of the child and the quality of the restrictions, what is the local authority to do? It can't do that without court authority because of Article 5. And on your argument, it can't use the inherent jurisdiction. But the child isn't within the categories of Section 25 threshold.
Well, we asked the court to consider Section 25, and in particular, we say the statutory scheme is broad enough. And in fact, that, if I may, is what I'd like to develop now. Why we say the scheme that exists, the statutory scheme that exists, is broad enough. And can I say at the outset that, of course, we appreciate that relief not being available for children who require it, it gives rise to a significant anxiety. And notwithstanding that, we say there are important constitutional reasons why the inherent jurisdiction should not be used. But we do rely on the statutory scheme, and we say that it is sufficiently broad to prevent children, as it were, falling through the cracks. And there are two reasons for that. The fact that non-local authorities, such as health trusts or care homes, can apply under the statutory scheme. They don't encounter the local authority bar, but also the breadth of the scheme itself. And so I think, if I may, I'd ask the court to consider some case law in relation to the development of the court's approach to Section 25, and start, if I may, with the judgment of Mr. Justice Cazalet in a Metropolitan Borough Council in DB, and that is set out at...
Sorry, Mr. Commissioner, before we move on to that, I would just like to obtain your comments to one proposition. As I understand it, you say that the local authority does not have parental power to confine a child in secure accommodation. And also, as you agree that a parent doesn't have the parental power to confine in secure accommodation. It may have the power to confine in lesser degrees of accommodation, but not in secure accommodation. Am I correct about that?
My Lord, no, what we say about the primary argument in relation to the local authority is that as an emanation of the state, it doesn't have the power. So it would be a different position in relation to a natural parent. That bar, as it were, does not apply. We then go on to develop grounds 2 and 3, as it were, or points 2 and 3, where the natural parent's position and the local authority's position do need to be regarded together.
Well, if I can bring you back to the orders that are made, the local authority isn't exercising its parental power before the order is made. My point is, once the order is made, it's exercising a power under the supervision of the court. And that is, it's exercising it by virtue of the court order, separate, distinct from its parental powers. So when you say that it's conferred and employed as a part of parental responsibility, what you say to the proposition that not at all, it is a power conferred by the court to a local authority under the control of that of the court.
When the court confers the power, it doesn't confine the child. It's not an order confining the child. It leaves that entirely to the discretion.
But I wonder if it does leave it entirely to the discretion, because there is an Article 5 obligation to have reviews. There's an Article 5 obligation to have liberty to apply. And so at all times, the court will step in and intervene. And so I was just wondering how you characterize it as part of parental responsibility, as opposed to under the supervision and control of the court.
Well, Lord, I don't accept the court does intervene, and I rely primarily, as it were, on the Court of Appeal's own judgment in this regard, which I think it's paragraph 84, and effectively says, to use shorthand, over to you, local authority. There you go. There are your powers. You decide what to do with them.
But it's not saying that it's completely over to the local authority, because it sets liberty to apply and will most certainly intervene if the local authority isn't acting in accordance with the powers given it.
Well, firstly, the idea that there would be an intervention by the court, I don't necessarily accept, my Lord, with due respect, because it would need the matter to be brought back to the court. It will go back to the court if the court sets a date for a referral, for it to be returned to the court, but otherwise it needs a party to bring the matter back to the court. And in a case where there are no statutory reviews, as there are required by the secure accommodation regulations, then the local authority is left to determine whether and for how long and how those powers are exercised. It would be rather like, I suggest, if I went to court as an individual to ask for powers in relation to my child. I'm given the power, but the day-to-day decision-making as to when to employ those powers and how to do those powers are implicitly, inherently parental powers. It's all to do with when you employ the power, when you don't. So it would be different, I suggest, if the court order confined the child, but the order doesn't do that. Quite clear, the order confers a power, and that power is then it's over to the local authority as to how to exercise it. So that's why we would say it is an exercise of parental responsibility, or in connection with parental responsibility.
Thank you.
Look, I'm grateful. Can I then, in relation to Metropolitan Borough Council and DB, which is the judgment of Mr. Justice Cazalet, this is a case, the reason I think it might be helpful for the court to consider this case is that it says 1032, and we see the facts at 1038. I suggest the reason might be helpful is that this is a case where two sets of orders were made. Orders confining under section 25, but also orders permitting medical intervention. So this, from 1038, we can see that the, I'm having difficulty finding my, page. Right, I have it now. I'm sorry. So at 1038, we can see that the young person was on a maternity ward at a hospital. I'm looking at about a third of the way down the paragraph beginning as to the application. So there's no issue about the fact that she could not leave because the doors to the ward were operated by a key to which she didn't have access. And the object and purpose of restricting entry was to ensure that outsiders couldn't enter, but also, in her case, that she couldn't exit. And so the learned judge said this in the next paragraph: it seems to me that having regard to the manner in which DB is confined to this ward, with the nursing staff instructed to prevent her leaving so that her life and health are not seriously endangered, this ward should be regarded as secure accommodation within the meaning of section 25. And then he confirms a decision of Mr. Justice Eubank, which I will in due course come to. But then at 1039, the learned judge refers to the then recent publication, or relatively recent publication, by the Department of Health, the Children Act Guidance and Regulations, which was guidance in relation to the definition of restriction of liberty. And in particular, it says this in the paragraph quoted, third line: however, it's important to recognise that any practice or measure which prevents a child from leaving a room or building of his own free will may be deemed by the court to constitute restriction of liberty. For example, while it's clear that the locking of a child in a room or part of a building to prevent him leaving voluntarily is caught by the statutory definition, other practices which place restrictions on freedom of mobility, for example, creating a human barrier, are not so clear-cut. And then the learned judge says this: it's important to note it's the restriction of liberty which is considered to be the essential factor in determining what is secure accommodation. To constitute secure accommodation, a place does not have to be so designated. Each case will turn on its facts. Now, we agree and submit the court should adopt that approach. It is the restriction of liberty which is an essential factor. The manner in which DB is confined in the maternity ward means that the ward had to be regarded as secure accommodation within the meaning of section 25. But then the judge also goes on to make orders about the medical treatment. We see that at the bottom of 1040, the last complete paragraph. The next question is the extent to which it's appropriate to remove from the order, which is outstanding, the provision as to reasonable force, and the order appears earlier in the judgment. And then he resolves that issue, and we can see how he resolves that issue. He resolves that issue by reference at 1042 to the local authority's parental responsibility. So the paragraph at the bottom before the quote: in my view, the local authority, in the particular circumstances of this case, is empowered to permit force to be used for medical treatment, to be prevented, to prevent serious danger to life or health. In other words, we've got two distinct features in this case. We have that aspect of parental responsibility which is invested in and retained by the local authority in respect of medical treatment, and those aspects of restriction which are ancillary or incidental to that treatment. But separately, we've got the use of the ward as effectively a secure unit. And so then when we come on to, if we may, re-see, and I think this is at 1377, this is the well-known judgment of Mr. Justice Wall in this area. He looks at, he considers this issue, I think it's at 191. So first of all, if I can take it in turn, he considers the powers of the court in respect of medical treatment at the top of 1385. In particular, he looks at the judgment of Lord Donaldson in Re W, and is content that he has ample power to make orders relating to medical intervention. And he refers to this as authority for him having the power to direct that C could remain as an inpatient at the clinic. And what he said is he noted that the Court of Appeal didn't deal specifically with the power to detain, but he inferred that there was such a power. And in the end, we can see the orders he makes, which appear at the end of the judgment at 1397. The orders he made were firstly interesting that the child do reside at the clinic for the purposes of treatment. And then permission or power, as it were, was given to the staff to detain or return the minor to the clinic and to use reasonable force, and leave generally to the doctors to furnish such treatment and care as that may be necessary to ensure she suffered the least distress and retained the greatest dignity. So the orders did not involve the local authority at all, but they did involve a curtailment or a restriction on the liberty of the person concerned, the young person concerned. And that I asked then the court to look back at 1390 and how he approached that by reference to the Cazalet judgment. In the second half of 1390, beginning whilst I respectfully agree, he says, premises which are not designed as secure accommodation may become secure accommodation because of the use to which they're put in the particular circumstances of individual cases. It does seem to me that the more natural meaning of the words provided for the purpose of restricting liberty is designed for, or having as its primary purpose the restriction of liberty. And he goes on to say, I therefore, at the end of that paragraph, prefer to look at the clinic and ask myself, is it accommodation provided for the purpose of restricting liberty? And that's a question of fact. And then at the bottom of the next page, 1391, he's satisfied on the facts that it's not a Section 25 case, and says this third line into that final paragraph, in my judgment, it's not accommodation provided for the purposes of restricting liberty. The primary purpose of placement of a child in the clinics to achieve the treatment, the accommodation provides a structure. The fact that such a structure includes a degree of restriction on the patient's liberty is, in my judgment, an incident of the treatment program. And the fact that steps can be taken to prevent C leaving the premises does not of itself render the clinic secure accommodation. So whenever a court sanctions medical treatment without or contrary to a child's consent pursuant to the inherent jurisdiction, there is necessarily a restriction of liberty. So what we say is the issue relating to the primary purpose is about deciding whether the restriction arises from the primary purpose of that medical treatment, so it's incidental to it, as opposed to the primary purpose being a freestanding restriction of liberty for the sake of the safety of the subject. Cazalet's case needed both, as the primary purpose of the ward was to restrict the young person, to protect her safety, not to administer medical treatment. But that was a factual determination. And we say the risk, therefore, is, and I submit that this is a risk that has been carried through, there's an extrapolation from these medical cases to ask in non-medical cases whether there's a primary or secondary purpose to the restriction of liberty. So in that context, and in that context only, we say, firstly, it's preferable to interpret the statute outside of the medical area, and where medical procedure is not the primary purpose, preferable to interpret the statute in the straightforward language in which Parliament enacted it. So provided for the purpose of restricting liberty. And the distinction, when looking at that sort of case between primary, secondary, tertiary, etc., is unwarranted, as indeed would be a distinction between designed for and the plain words provided for. Secondly, to the extent that accommodation is provided for the purpose of restricting liberty, to the extent it constitutes a deprivation of liberty, it's hard to see how the deprivation, if only incidental, could ever be necessary or for the purpose of one of the aims enshrined in Article 5. And of course, Mr. Justice Ward himself approached the issue on the basis that premises not designed to secure accommodation could nevertheless become secure because of the use to which they're put. And accommodation of children by health authorities or local authorities in the exercise of educational functions are all examples of accommodation, it's presumed, in which it might often be said that restriction of liberty is an incident to or not the primary purpose. But even there, it's still explicitly capable of being caught by the scheme. So moving away, as it were, from historically how this has been approached, the preferred approach should be that of Mr. Justice Cazalet, and the distinction between those cases where it's medical treatment and restriction ancillary to or incidental to. And so we agree and submit that the court should find that what is important is the restriction of liberty, which is the essential factor in determining what is secure accommodation. And that is, I think, where I would, if I may, say that the court has relied upon the courts have relied upon and indeed other cases, such as the case of Re B, which is at 3083, where a court was persuaded to invoke the inherent jurisdiction to confine a 17-year-old on the basis that Section 25 should be applied. Mr. Justice MacDonald, in the case to which I referred at the outset, considered that was probably wrongly decided because there wasn't proper consideration in that case. But that Re B case, together with Re C, are very often cited as reasons for invoking the inherent jurisdiction for this parallel procedure. In our submission, there should be, where Section 25 applies, no parallel procedure. Ladies and lords, with your permission then, I'll move on to the next part of our ground 1B, and that is the lawfulness of the placement in which the placements in which the appellant found herself. So there were two placements. The first was not registered as a children's home, and it may be worth, in due course, the court considering what is said about the children's about that placement by the appellant in her recent witness statement. In particular, and that's at EF 810, but in particular, by way of the edited highlights, as it were, it was a transport company that had no prior provision of care available to it. The proposal came from the appellant herself as a result of building a rapport with the CEO of that company in a car journey. It's clear that that organisation had to source and establish accommodation with only 48 hours notice of the arrival of the appellant. There's very little education, and she was, within that scheme, placed in two different types of accommodation, even within that provider's scheme. The second accommodation, in contrast, was a registered children's home, but was not approved to be used as secure accommodation. Our submissions relating to the inherent jurisdiction not being accessible, precise, or foreseeable, when employed as a remedy to parallel the statutory scheme, apply to both homes. Whereas in the case of the first home, the home is unregulated, submissions as to the consequential unlawfulness and lack of educational provision are limited to the unregulated market and applying to that first home. Now, there can be no doubt that each respective home was provided in order to restrict the appellant's liberty. So dealing with that point, paragraph 12 of the judgment is at electric number 4, the first instance judgment, I should say, 423. The judge said that he considered the order was justified. I'm fully satisfied that one or other the limbs of Section 25 is satisfied. I'm satisfied there is here a history of absconding and that without the restrictions of a secure accommodation order, she is likely to abscond. And if she were to abscond, is likely to suffer significant harm. I'm also satisfied by the alternative limb, that if she was kept elsewhere, and of course elsewhere means other than in secure accommodation, she would be likely to injure herself. Therefore, in each alternative as set out in section 25, I'm satisfied that that justifies in making the order which he then makes. So I'll then move on, if I may, to the unlawfulness. So firstly,
sorry, Mr. Chairman, was there any factual dispute before the judge as to whether these two, well, the first placement was or wasn't secure accommodation? And was there any evidence led before him? Was that issue being decided by him? Because I interpret those remarks that he's made in paragraph 12 as a general proposition, that she needs some degree of security, rather than this is secure accommodation. So the first question is, was there any factual proof or evidence before the judge?
Yes, so there was a care plan, which we do have in the most recent
and does it describe this accommodation?
No, because this accommodation, from what I can see, the nature of this accommodation was raised at court for the first time. So there was discussions about alternative, what's termed bespoke accommodation, which would require a deprivation of liberty order from the court. But that which was envisaged was not then permitted by the Welsh government. But at court, the availability of the accommodation that was ultimately used was raised for the first time.
Did the judge have the evidence to form a view as to whether this was secure accommodation?
Well, I think there's no doubt about the fact that this was secure accommodation, and this was presented to the judge in that way because, for example, and I'm looking now at this is the local authorities written case, electronic page 225. And there, paragraph 28. And halfway through the paragraph at the top of the page, Justice Mostyn considered both as placement options and concluded that on balance, the latter was better. The court, children's guardian, the appellant were all aware the placement was not registered. The registration was pending, and at paragraph 29, the court had approved. The relevant authority was then told that the court had approved the unregistered placement. Then the contract specified in detail the expectations, including implementation of the deprivation of liberty. And they say throughout her placement, she received a high level of social work involvement, and that there were regular deprivation of liberty review meetings and professionals meetings. When the learned judge came to his conclusion at paragraph 12 in his judgment that this is a case to which section 25 applied, he did so on the basis of what he says were undisputed facts at paragraph 11. In other words, this was a child who needed to be detained for her own protection, and he was therefore satisfied that both limbs were made out. And when he expressly says, as he does,
I understood the evidence to be that she needed to be detained in an environment that gave her slightly more liberty than she would have in what is termed secure accommodation. That was the basis upon which the case was being run, and so that she could develop and have a degree of independence. So I'm just a little bit uncertain as to whether or not there was any dispute before the judge, any finding by the judge that this was secure accommodation.
would I say there was no, there was no dispute. I'll be corrected by the local authority if I'm wrong about that, but I believe there was no dispute. And as I say, the plan, of course, was to move her towards independent living, and the plan was to lessen the restrictions. But the judge expressly says at paragraph 12, if she were kept elsewhere, she'd be likely to injure herself. That's an that is a direct reference to section 25, which says an order can only be made for secure accommodation if the harm that's envisaged cannot be guarded against by any other form of accommodation. And so he's there saying this is not that other form of accommodation. This is secure accommodation. So I say it is clear, but I'm sure the local authority will correct me if there was an issue about that. What we know, though, is that whilst the second accommodation was a children's home, we also say the first accommodation was a children's home. The definition is, for the purpose of the Children Act, is set out in section 105 EF 872 to have the same meaning as that in the Care Standards Act. The Care Standards Act is at 921, and that tells us that a children's home, accommodation establishment rather, is a children's home if it provides care and accommodation wholly or mainly for children. And then in regulation, in section 4, section 4, 929, it says expressly any reference to a description of an establishment is a reference to a children's home in England. Separately, a children's home providing accommodation for the purpose of restricting liberty. And then section 11 at 936 sets out a requirement to register any person who carries on and manages an establishment of which a children's home is one of any description without being registered in respect of it shall be guilty of an offence. So turning to this case, the judgment is clear. Firstly, as I say, the judge was sanctioning a child being placed in quasi-secure accommodation. The Children's Commissioner suggests in her written intervention that placement of a child of any age in unregulated placement will always be unlawful, either because the placement is providing support at a level below the threshold required to constitute confinement, or would in reality be providing both support and care. So the appellant in the first accommodation was the only resident. She was subject to a care order. The local authority was obliged to care for her, was obliged to have a care plan for her. It wished to restrict her liberty. It wished to restrict her liberty as part of that care plan. So, pursuant to its obligations to care for the appellant, it placed her with the first accommodation, and there she stayed for many months. And indeed, the contract, we can now see the local authority has, in its recent statement, set out the contract, which was a contract for care and accommodation. We also know that even on the local authority's case, and this is at their paragraph 28, EF 225, that property was seeking registration. If that was not a registration as a children's home, then it's hard to understand what it was registration for. The court order is at 411 electronically, and that recites the fact that it was a placement yet to be registered by Care Quality Commissioner Andrew Ofsted. And the exhibit to the witness statement of the appellant demonstrates how even after the appellant had left that property, it was continuing to seek Ofsted registration. And this situation is somewhat commonplace. So although Secretary of State affects to not understand our reference in our written case to an unregulated children's home, we say only mean one thing. It's not being registered. It cannot be regulated under the statutory scheme. And so it follows that although that first placement was acting as a children's home, it was not registered. And in any event, it fell outside all regulation. Moving on then, Article 5 is, as we set out in our written case in the first rank of fundamental rights. It requires that any deprivation of liberty must be in accordance with the procedure prescribed by law, and that includes the requirement it must comply with domestic law. The Secretary of State submits that it's the operator of a home which acts illegally, yet we submit the court can never condone unlawfulness. By placing the appellant in that first home, which had never cared for a child before, it was permitting that operator to act in contravention of Section 11 of the Care Standards Act. But for the appellant's placement, there would have been no breach of domestic criminal law. So the placement of the appellant directly caused the commission of an illegal act. It cannot be in accordance with UK law to make an order under the inherent jurisdiction that inevitably gives rise to the commission of a criminal offence by another in relation to the child in question. The Secretary of State submits that our submission misses the point at their paragraph 86 because the placement was carried out pursuant to a court order. And so it would follow from their submission that the Secretary of State would consider that it will always be lawful if the court makes the order. But firstly, this would render nugatory the safeguard provided by Article 5, that in order to meet the requirements of lawfulness, detention must be in accordance with the procedure prescribed by law. Or, for example, put another way, if a court endorsed circumstances which amounted to, for example, inhuman or degrading treatment, the making of the order would not make those actions any less unlawful. We certainly accept that court orders are valid until set aside, even if not correctly made. But it cannot be the case that a court can, by sanctioning an illegal placement, authorise a criminal offence. The question in the appeal is whether the order that led to detention was lawful, not whether once the order had been made, the detention was lawful. In our written case, we refer to the detriment to the child of confinement in a children's home that's not regulated, as it falls outside the Care Standards Act and doesn't meet the quality standards in the Children's Home Regulations of 2015. It's neither inspected nor approved by Ofsted. And we submitted that in the absence of these safeguards, the courts in practice are simply not well placed, nor do they scrutinise those matters that are otherwise the focus of objective, independent consideration by, for example, Ofsted, because the courts don't have the detailed and specific evidence which enables them to consider, for example, the quality of the provider of the educational supervision, the aims and the scope of the proposed educational supervision, and the ability of the provider to meet those aims. The effect of that is clear, not least from the local authorities written case, which sets out a number of concerns about that first placement, arising as early as October 2017, when the appellant remained there for another 5 months. And we, if we may, just draw attention to the Children's Commissioner, who identified, excuse me, 3 cases in their written submissions, which they've considered might illuminate the discussion in respect of lawfulness under Article 5.1d, and in particular draw the court's attention to Lokin and Russia. That's set out at EF 3759, but in short, taking the Commissioner's case, that educational supervision must take place in an appropriate facility with resources to meet the necessary educational objectives and security requirements. That mirrors our submission that the absence of, for example, Ofsted inspecting denies to the court very basic information. And in the absence of that information, the placement is prone to be unlawful. The Commission also refers to DL and Bulgaria, the need for the state to put in place appropriate institutional facilities which meet the demands of security and the relevant educational objectives to satisfy 5.1d. Again, the court is denied by the absence of any objective external system of inspection or independent assessment, the ability to assess the relevant educational objectives at the proposed unregulated home. I will perhaps come on in a moment to education and in particular the children's homes regulations, but I'm aware of the time, and would this be a good point at which to break?
Thank you very much indeed, Mr. Toomey. It would be a good moment to take a 5-minute break. We'll reconvene in 5 minutes. Thank you.
Right, thank you.
Yes, Mr. Toomey, thank you very much.
Lily, thank you. I was going to move on to the children's homes regulations. Can I do that by just referring the court to them rather than taking you through them? They're found in particular, could the court consider regulations 4 and 8? They are at page 2113. Briefly, that's regulation 4. If I can just identify for the court's benefit what appear to be 9 particular quality standards guaranteed by the children's home. And each of the standards is set out there by reference to a particular paragraph or particular regulation, which then follows. And for particular purpose of education, the relevance is regulation 8, which is at 2119. And again, without taking the court slavishly through each line, just identify what I think are under, for example, the requirements relating to staff, paragraph 82A, 10 requirements about what is required of staff in a children's home to assist children in meeting their educational goals, and to identify, therefore, the significance of all of these standards, but particularly the significance of the education standard. And then I may move on to look more broadly then at the accessibility of the inherent jurisdiction as this parallel process. And these submissions, therefore, relate to both homes. If one is to ask the question whether the exercise of the inherent jurisdiction is based on wider grounds in section 25, then in our submission it's far from clear that the current state of domestic law provides an answer to this question. 2 illustrations can be found from this particular case. Firstly, the judgment of the learned trial judge, and in particular, can we look at the EF 420, which is the judgment of the 23rd of January. And at the bottom of 420, paragraph 5, how the learned judge approached it, the parallel scheme. It seems to me, so therefore it seems to me, if the court is to make an alternative mirror order pursuant to its inherent jurisdiction, it should strive to ensure, in the first instance, it's not longer than 3 months, and that each subsequent renewal is for no more than 6 months. Further, it should be satisfied initially and on each renewal that the criteria within section 25.1 are met. Then says this: I'm not saying that the court is imprisoned within the 4 corners of the terms of section 25.1. And he goes on to conclude, were that not so, then perhaps there would be, by judicial activism, established an alternative scheme which perhaps might have lower standards than that which Parliament has decreed should apply where the liberty of a child who's a subject of a care order is deprived. And so what we say about, for example, this is it's entirely unforeseeable as to how the law stands now to know what is meant by a court making its best endeavours to see criteria are met, or the court meeting criteria under section 25 in the parallel scheme as far as possible. And indeed, what we say the learned judge identified as the mischief to be avoided is indeed the mischief that is being created. So his orders had precisely the effect that he said should be avoided. So the appellant was placed in an unregulated accommodation, denied the statutory protection, denied the... Sorry, lady.
I didn't mean to interrupt at all. I just wanted to indicate I'd like to ask a question at some point. Isn't there a danger here of confusing 2 issues? One issue is, in what circumstances should a judge exercise the inherent jurisdiction and with what safeguards? The second question, and really it comes logically first, is whether as a matter of interpretation, the inherent jurisdiction has to any extent been displaced. And that's a question of statutory interpretation, not a question of whether he imposes particular restrictions in terms of time and so on. That's really quite separate.
Yes, I completely agree, my lady, if I may say. And in relation to that, the latter of the 2 points, we address that, and if I may, I'll address that in my next part of for ground 1C. But I entirely accept what my lady says about the right way around, as it were, to approach the scheme. And it's perhaps unfortunate that my submissions don't come that way around.
Okay.
Please forgive me if
No, as long as we're on common ground about where we're going. Thank you.
Absolutely, Mary. Thank you very much. So in relation to the Court of Appeal judgment, we see this difficulty as well, I suggest, and that is at paragraph 79 of the Court of Appeals judgment. So that is electronic page 408, where the court said that, and this is in the 4th line, the terms of section 25 should be treated as applying to the same effect when a local authority is placing a child in the equivalent of secure accommodation. So here the court clearly has in mind the whole of section 25 travelling over to be applied under the inherent jurisdiction. But we identified the following difficulties with that. Firstly, it imports a statutory criteria where welfare is not paramount and transplants that into a jurisdiction where welfare is paramount. So what, for example, is the court to do if an order satisfying the section 25 criteria were not in the child's best interests? And that might occur because, of course, section 25 is not just focused on the child, but potentially focused on the threat of the child to third parties. Secondly, what about the other exceptions to section 25? So, for example, is it permissible for a child to be placed in an approved registered children's home, but where the Secretary of State has imposed conditions as the regulations permit, but the conditions, or a significant condition, has not been met? Would the inherent jurisdiction be able to sidestep that failure to comply with the significant condition? Or a child under the age of 13 to be placed in an approved children's home, but the Secretary of State has not approved that course for the child, as the regulations require under section 25 and the 91 regulations must happen, or approval has been sought and denied. Can the child still be placed in that home under the inherent jurisdiction in the face of the lack or refusal of approval? And how is the absence of a Secretary of State's approval to be treated by the inherent jurisdiction? Really, why and in what circumstances should the court authorise a placement of Parliament as directed must be approved by the Secretary of State? And then timing. An order is required, for example, in a given case in excess of the time permitted by the regulations. If the approval of the Secretary of State for a proposed children's home can be sidestepped, why can't the time periods? And if so, what are the principles involved? And if any one of these examples apply and can be tolerated under the inherent jurisdiction, what if then there's a number of them all at the same time? So a child under 13 without Secretary of State approval, or an approved home to go to? And what combination of carve-outs, as it were, from the statutory scheme is permissible? And then the Court of Appeal judgment at paragraph 84 refers to this, that I should make it clear this case does not concern the placement of children in other than the equivalent of secure accommodation. We saw clarification of that phrase, none was provided, but an example appears at the end of the paragraph, local authority in D, but that example is problematic. And can I just give the court the reference and perhaps it were asked to take from me what that case was about? It's at electronic page 3121, where the child was confined because he was noted to exhibit overly sexualized behavior towards other children and engaged in behaviors which put himself and others at risk, at high levels of aggression. he had barricaded himself in a room and threatened to self-harm. Local authorities submitted it fell outside of Section 25 because the home was not approved as a secure accommodation home. The official solicitor said that the reasons for the deprivation of C's liberty were the same as those set out in Section 25. So in other words, this was precisely the same sort of case as this appellant's case, a Gillick child who could have satisfied Section 25 and could have been placed pursuant to an order under Section 25 had an approved home been made available. So how, applying the Court of Appeals language, is a placement of a child in other than the equivalent of secure accommodation to be understood? And finally, if the Secretary of State asserts that all that's happening in these cases is that the court is sanctioning a deprivation of liberty and no more, how is one then to approach the second sentence of this paragraph of the judgment? Different considerations will apply when an application is directed towards and only directed towards a deprivation of liberty. I think I then refer to there are other, yes, then I think, can I just refer to other cases as two examples? There are cases where Section 25 is said to apply, as I've indicated, but the inherent jurisdiction is used because of the unavailability of homes. Then there are cases where the court has proceeded on the basis of welfare, on acknowledging the criteria under Section 25 are not met. And such a case is AB, a child deprivation of liberty 2015, which is at electronic page 1019. So we say, as things stand, a local authority could, on current law, seek an order under Section 25 in relation to an approved registered children's home, fail to satisfy the criteria under Section 25, and then make a second application in relation to a neighbouring unapproved or unregistered property pursuant to the court's inherent jurisdiction, and the child would then face an order for their confinement. And we say there's nothing to stop that as things stand. An order made pursuant to the inherent jurisdiction is necessarily made subject to the principle that the child's welfare is paramount. Statutory scheme welfare is relevant, but not paramount. And so I've indicated there already that an order for the protection of a third party, so 25(1)(b), is not necessarily appropriate when the child's best interests are paramount. Secondly, if one is to import the statutory scheme into the inherent jurisdiction, then would mandatory direction under Section 25(4) similarly be imported? And it's hard to square mandatory orders in an area of the law that is concerned with promoting and having as its paramount consideration the welfare best interests of the subject child. Ladies and my lords, may I now move on, with your permission, to ground 1C, and in particular, the point that Lady Arden was concerned with in the latter part of her question to me. And this submission arises out of the conclusion of the Court of Appeals judgment that the inherent jurisdiction may be used to authorise the placement of children in the equivalent of secure accommodation. And again, we've looked already at paragraph 79, where that phrase arises, and where we say we're unclear as to the meaning of that phrase. But if I can now look at Section 25, and in particular, the regulations made under Section 25. So Section 25 is set out in the bundles at page 851. And there are similar terms for the Welsh statute. And the first point And I'm going to here, I appreciate, and the court will appreciate, there are other children who may be caught by Section 25, but helpfully the statute refers to the type of child we're concerned with, a child who's being looked after by a local authority. That's defined for English purposes by Section 20 and Welsh purposes by Section 74 of the Social Services and Wellbeing Act 2014. But they're in similar terms. So that is, in our case, a child subject to a care order. Other children under the regulations are caught by Section 25. So the regulations made under Section 25 bring in other children, so children provided with accommodation by health authorities, local authorities in the exercise of educational functions, and children other than those looked after who are accommodating care homes or independent hospitals. So we say that firstly, the appellant was a relevant child, a child to whom this section applies. She was looked after by the local authority by virtue of the care order. And secondly, the accommodation in both places was provided for the purpose of restricting her liberty, and so consequently Section 25 applied. When the first order was made, the local authority satisfied the court that but for the first accommodation not being a registered secure unit, an order for secure accommodation would have been made. And so there can be no doubt, we say, the appellant was a looked after child. The local authority was seeking to place the appellant in accommodation provided for the purpose of restricting liberty. Neither of those placements was approved secure accommodation. That is to say, neither was a children's home registered by the Secretary of State and approved for use as secure accommodation in line with the regulations. And the regulations are to be, the relevant regulations to be found at 893. Last at 891 and 893 sets out Regulation 3. Accommodation at children's homes shall not be used as secure accommodation unless, in the case of accommodation in England, it has been approved by the Secretary of State for that use. So it's clear accommodation in a children's home shall not be used as secure accommodation without Secretary of State approval. So it follows that such accommodation shall not be used for the purpose of restricting the liberty of children to whom Section 25 applies. So if one places a looked after child under the inherent jurisdiction in accommodation provided for the purpose of restricting their liberty in a children's home which does not have Secretary of State approval, we're acting in contravention of this regulation. We're doing what Regulation 3 prohibits. It's not in accordance with the law. The position is just as clear in the Welsh regulation. We've set the Welsh regulation out in our written statement. There are two. The regulations changed over time, and it's just perhaps more convenient to look to our written case where they're set out side by side. Page 197. We set out the first in time, the change being relevant only to the third order that was made in this case. The first two orders subject to the first Regulation 8. A local authority may only place a child in secure accommodation in a home which is registered as a children's home, providing accommodation for the purpose of restricting liberty. So we say it's yet clearer there, and clearer still by the further regulation which applied subsequently. The Children's Commissioner for England has intervened because she's concerned that the current system does not meet the needs of vulnerable children, and so she would like to see increased safeguards and protections for these children. And she provides, for the benefit of this court, some detail as to the safeguards which apply, and they are, I think, largely set out in the footnotes to her written case. She points out that secure children's homes are inspected twice a year by a dedicated Ofsted team. There's a separate framework for inspecting them because of the increased vulnerability in closed settings. Children's homes that hold children deprived of liberty but are not secure units may only have an inspection once a year if they're good or outstanding, and will not be inspected against the Secure Children's Homes framework. Ofsted do not routinely request information on all children deprived of liberty as part of their inspections, and there's no information about where children are deprived of liberty, where they're living in the parallel scheme. It's not possible, therefore, to ensure that they're visited by the National Preventative Mechanism. We also provide at paragraph 25 some of the disadvantages suffered by children whose liberty is restricted in non-approved children's homes. And we have now, we say, greater detail courtesy of the Children's Commissioner. And we rely and endorse the approach taken back in 96, 97 by Mr. Justice Wall, when, and I think the reference, I hope, is at 2316, in that case of REC. No, it's not. Find that. At
it starts at
sorry,
1378.
thank you, 1378, forgive me. And 1388, the approach of Mr. Justice Wall, at the bottom of that page, the use of the words applications to a court under section 25 shall be made only by clearly limits the persons or bodies who may make applications for secure accommodation orders, and thus restricts the powers of the court to make such orders. And then this, it follows that if 1, the clinic is secure accommodation, and 2, C falls within the category of persons set out in the regulations, the inherent jurisdiction of the court is ousted. And for C to be detained in the clinic, an application under section 25 needs to be made. This, we submit, is how this court should approach section 25. We say that Mr. Justice Wall, as he was correct in his approach to the inherent jurisdiction and the risk of using it where section 25 applied. We draw some further submissions then from the approach of then Lord Justice Hoffman in Re-M, and can I ask the court electronic reference 3366, his approach to the Act. So at the top of 3366, letter B, he said the Child Care Act 1980, being concerned with the powers and duties of local authorities, contained no equivalent of Section 1 of the Children Act. And it seems to me very unlikely that Section 25 of the latter Act was intended to have a different effect from Section 21A of the Child Care Act 1980. The function of the court under Section 25 is, in my view, to control the exercise of power by the local authority rather than to exercise an independent jurisdiction. So dissection is expressed not as the grant of a power to keep children in secure accommodation, if the conditions in paragraph A or B are made out, but as a restriction on a power which is assumed already to exist. So this is important because Section 25 applies equally to children for whom the local authority may or may not have parental responsibility. And the expression of the section as a restriction on power surely means that Parliament was saying, whatever power you may have had to restrict the liberty of the looked after child, that power is restricted by statute. So if the local authority had the power to confine a child pursuant to its parental responsibility, granted with its care order, that part of its parental responsibility is now restricted. So to that extent, it doesn't matter whether in a given case a child's liberty is lawfully prone to be restricted. This section tells us that that power is removed unless the criteria of the section are met, which means that the all-important questions for this court is whether Section 25 applies to the appellant in either or both cases in which an order was made under the inherent jurisdiction, and we say it did. The statute applies the section to looked after children, and the statutory instrument extends the range of applicable children. And so we draw some comfort in our submissions by the wording of Section 25, and in particular Section 25(7), and that is at, I hope, 852. By by Section 25(7), the Secretary of State may do 4 things. If I can ask courts to look for the moment at 7A, he can, by regulations, provide that this section shall or shall not apply to any description of children specified in the regulations, and of course has done that. In contrast, in relation to the power to limit the placement of children in certain types of secure accommodation, particularly in the case of children's homes, that the said home has been approved for that purpose by the Secretary of State, the enabling section does not refer to the application or disapplication of the Act, rather than describing where the Act applies. This provision, as in each of B, C, and D, describes how the section may or may not take effect. I know there were, I should say, some submissions in relation to this in the case of D before this court, to the effect that secure accommodation in a children's home is only such if it's approved for that purpose. But we say that's wrong. We say, firstly, the term secure accommodation is defined in the statute and in the regulation at paragraph 2.1 as being accommodation in England provided for the purpose of restricting liberty. There are no conditions or qualifications, and we say it would be wrong to imply any. But firstly, the definition of secure accommodation applies to accommodation other than children's homes and in relation to categories of children other than looked after children. The court could not contemplate a different meaning of the term secure accommodation depending on where or depending on whose application or by whose application the child is to have their liberty restricted. Furthermore, if that definition that was argued for in Re D were to have effect, the consequence would be that no matter the circumstances pertaining in a home that's not approved, that child is not within Section 25. And then that would remove the child from 2 protections, the protection deriving from that home having been approved, which is significant, as I already set out, but also the protection afforded by the court's consideration of the strict criteria in Section 25 and the protective effects for children committed to secure accommodation, particularly by way of reviews under regulations 15 and 16 and keeping of records under regulation 17. And then Section 25(1)(b) sets out one of the 2 conditions for making an order under Section 25, referring to a child being likely to injure himself or other persons if he is kept in any other description of accommodation. And that's a reminder of the terminology used by the learned judge of first instance to which I referred. So this in turn refers to accommodation other than secure accommodation. So this clearly means any other accommodation not provided for the purpose of restricting liberty. If the term secure accommodation has 2 different meanings, then this condition is completely uncertain. And then by regulation 3 of the 1991 regulations, accommodation in a children's home shall not be used as secure accommodation unless it's been approved by the Secretary of State for such use, and approval shall be subject to such terms and conditions as he sees fit. So to follow the logic of the argument previously advanced, the application of Section 25 would be limited in the case of children's homes, not just to those approved, but also compliance to any terms and conditions imposed. Generally, it would be an extraordinary matter for the Secretary of State to impose a condition when giving approval, for that condition not to be met, and thus for the application of Section 25 to be wholly sidestepped. And for that same non-compliant accommodation then to be used as equivalent to secure accommodation through an order under the inherent jurisdiction. Further, we'd ask the court to consider a case decided under the 1980 Child Care Act, and this is the case of Mr. Justice Eubank in the Crown and Northants Juvenile Court, ex parte, on the Borough of Hammersmith and Fulham, and that is at EF 1307. And we can see at 1308, the former statute, the Child Care Act, providing for a child in the care of the local authority may not be placed, and if placed, may not be kept in accommodation provided for the purpose of restricting liberty, unless it appears that, for example, that if he is kept in any other description of accommodation, he's likely to injure himself or other persons. So similar wording. In that case, the juvenile court rejected the application on the grounds that the John Clare unit was not accommodation provided for the purpose of restricting liberty. The reason given was that the phrase accommodation provided for the purpose of restricting liberty meant accommodation provided with the approval of the Secretary of State. The justices were led to this conclusion by the provisions of the secure accommodation regulations. And we can see at a point about 2/3 of the way down, page 1308, under Regulation 2 of those regulations, secure accommodation was described as accommodation in a community home for the purpose of restricting the liberty of a child resident therein. Mr. Justice Eubank's view, in the final paragraph beginning at the end of that page, there was no justification for the justices to come to the conclusion that accommodation provided for the purpose of restricting liberty meant anything other than what it said. There was no justification for limiting accommodation to accommodation provided with the approval of the Secretary of State. The purpose of the section, he said, in my judgment, is that children who are in care of a local authority are not to be locked up or kept in accommodation provided for the purpose of restricting liberty without the authorization in those terms of the juvenile court. We say the reasoning which requires authorization pursuant to the statute remains good today. And significantly, unlike Section 21A of the 1980 Act, Section 25 now does use expressly the term secure accommodation. It appears in inverted commas, does so directly after the phrase accommodation provided for the purpose of restricting liberty. So that's shorthand to indicate this is the definition. And in other words, this latest incarnation of the statute expressly confirms the approach of Mr. Justice Eubank and puts the matter, we say, beyond doubt. The statutory instrument is in exactly the same terms. It's also significant that the children's homes regulations define not secure accommodation, they define a secure children's home. That's at 2109. If the statutory scheme is intended as a restriction of powers which already exist and imposed by Parliament, the consequence, we say, must be that where it applies, the scheme ousts the jurisdiction, the inherent jurisdiction. So where Parliament has, by the statute, expressly said that a certain class of child may not be placed in a certain class of accommodation, the inherent jurisdiction cannot be employed to sidestep that express prohibition. And this must particularly be the case where the court is dealing with the liberty of the subject. The regulations by which Section 25(2) are delegated to the Secretary of State place only one restriction on the use of accommodation, and that's that a children's home shall not be used unless it has approval from the Secretary of State. And so it will not escape this court's attention that the prohibition is therefore one imposed by the Secretary of State pursuant to his statutory powers. It's the only prohibition imposed by regulations brought in by the Secretary of State, and yet it's one which he invites this court to ignore by permitting the prohibition to be avoided by the use of the inherent jurisdiction. In our submission, there can be no clearer example of the inherent jurisdiction cutting across a statutory scheme, and we can ask the court to consider in due course the Law Commission's working paper, which is at 4538, and its wonderful reference to the difference between a hole in a blanket, which needs to be patched, and the hole in a Swiss cheese, which is part of the fabric and virtue of the cheese itself. But it's difficult to describe in legislative language. We submit that the limits of the scheme are part of the scheme. The forbidden nature of the children's homes not approved by the Secretary of State is clear, express, and part of the scheme. We've referred in our written case to the words of Lord Hailsham in Richards and Richards. Can I ask the court to consider or reflect upon the words of, in the famous De Keyser case, the words of Lord Dunedin and Lord Atkinson? In the former case, page 1063, inasmuch as the Crown is a party to every Act of Parliament, it's logical enough to consider that when the Act deals with something which before the Act could be affected by the prerogative, especially empowers the Crown to do the same thing, but subject to conditions, the Crown assents to that and by the Act to the prerogative being curtailed. And Lord Atkinson at 1076 to 7 put it this way: the statute abridges the royal prerogative whilst it's in force, that the Crown can only do the particular thing under and in accordance with the statutory provisions, and that its prerogative power to do that thing is then in abeyance. And if Parliament had wanted children to be placed in accommodation that restricted their liberty based on the welfare best interest of children, it could have done so. But for Parliament to set out clear and strict criteria and to say that those criteria are met and not to use them is concerning democratically. It's hard to see how Parliament could have used wording which was more clear than the words may not do so unless. In the era preceding the commencement of the Children Act, wardship was sometimes used both when a child was voluntarily accommodated or accommodation under a care order. In the latter case, Professor Cretney tells us that the court would not use its inherent jurisdiction to substitute a judge's own views as to the best course to be adopted as to care and control of the child, as long as care was invested in the local authority. But there were exceptions, which included where the local authority was found to be acting outside its statutory powers, or wasn't exercising its powers in good faith, or was exercising discretion improperly. So it seems curious, therefore, perhaps striking, that the court's invited to sanction the use of inherent jurisdiction to permit a local authority to do that, to act outside of its statutory powers. We are not, we say, talking about a removal, an ouster of the inherent jurisdiction sub silentio, Secretary of State asserts. We're saying the inherent jurisdiction is ousted as a consequence of the express terms of Section 25, including the Secretary of State's own regulations made pursuant to it. And there are, we say, surely broader implications for the approach adopted by the Secretary of State. Whenever the Secretary of State exercises his statutory powers to lawfully restrict something, that restriction can and indeed should be ignored. So where the Secretary of State says there is a lacuna, we say simply no, there is no lacuna, there is a deliberate restriction. And we say it's not credible to imagine there is a lacuna given the extensive preparation and presentation leading up to the passing of the Children Act. There's no room for the assertion of an inadvertent gap. It's clear that Section 25 and the regulations made thereunder, which came into effect on the same day, were a deliberate means to create a statutory route by which the court authorisations based on defined criteria would authorise restriction of liberty in establishments. The fact that Section 25 was merely a continuation of the previous legislative scheme reinforces that view. Where the Secretary of State asks what should be done in these cases, we say the answer is, firstly, not to exercise a jurisdiction on an impermissible basis, but perhaps more significantly, authorise more and authorise more varied places. In this case, we know that at the time the application was first heard under the inherent jurisdiction, the local authority had no viable placement for the appellant, as the Welsh Government did not approve the proposed carers who were not registered for the care of the children. On the 19th of July 2017, the first care home was not registered, but was presented to the court on the day. By September 2017, the local authority was very concerned. Responses about registration and the appellant's welfare had become unsatisfactory. And we read this all from their own case, for example, 226. At the same time, the local authority became increasingly concerned that the home was not implementing appropriate boundaries, structure or routine. And the local authority and the children's guardian all agreed the appellant needed to be moved. But despite all of those concerns, the court endorsed that home as being appropriate and in the appellant's best interests in January 2018. Even on the local authority's case, that home was far from suitable and was not meeting the appellant's needs. She was to spend about 8 months there, notwithstanding the profound disadvantages, when she ought to have been in approved, secure accommodation with all the protections that affords her. And whilst it's not the court's job to fashion remedies to correct a failure by the state to provide adequate, suitable provision for needy children in need of secure and beneficial establishments, we also note the occupancy rate recently has been said to be in the order of 73%, and historically has hovered somewhere between 70 and 80%. So I'm looking at the document provided by the local authority at electronic page 591. And so, in conclusion, it's perhaps worth pausing to consider if what has happened in this case is permissible, then what about other exceptions? So a child to be placed in an approved registered children's home, but conditions have not been met. An under 13-year-old placed in the children's home, the Secretary of State neither approved or perhaps refused permission, or an order required in excess of the time permitted under the statute. And if any one of these examples can apply and be tolerated under the inherent jurisdiction, then in our submission, that illustrates the inappropriate and impermissible nature of the use of it. My ladies and my lords, I have one final ground to address, if I may, and that is the issue of consent. And this is made if, contrary to our submissions, inherent jurisdiction was available in this case, the court would need to consider whether to make an order was in the appellant's best interests. Now, Mr. Justice Wall noted in the references electronic 1377 at 1386 that in that case of Recy, to which I've already referred, it was common ground that in exercising this particular aspect of the court's inherent jurisdiction over minors, Section 1 of the Children Act applies, and the welfare of the child is my paramount consideration. At 1381, he considered the question, how relevant to the exercise of the power is the child's capacity to consent or to refuse treatment? He answered it at 1392. C's capacity to give or refuse consent to treatment is relevant to my decision, but is not determinative of it. Clearly, however, if the evidence is that C has the capacity to give or refuse consent, then the weight which should be given to her wishes is increased. This approach, we submit, is to be preferred to that which we say was adopted by the Court of Appeal in this case. In its judgment, the Court of Appeal, we say, has drawn a distinction between cases in which consent is relevant to the exercise of the inherent jurisdiction and cases in which it is not. The relevant paragraphs are paragraphs 79 and 84, respectively pages 408 and 409. In our case, at our paragraph 100, we identified two categories, 1 and 2 in paragraph 79, and one further in paragraph 84. The paragraph 79 said that Parliament has decided that only a court can authorise a Section 25 placement, so that consent is not relevant. We call that case 1. Consequently, it's then said that when placing a child in the equivalent of secure accommodation, a child must then also be unable to consent. So even though it's a welfare paramountcy jurisdiction, consent cannot authorise the placement because a statutory scheme is being imported into the inherent jurisdiction. This feature alone highlights the problems with importing a scheme where the child's welfare best interests are not paramount into a jurisdiction where they are. The Court of Appeal then distinguished, and this is at paragraph 84, the case of a child placed in what is described as other than the equivalent of secure accommodation. Again, the term's unclear, but it's further described as an application which is directed towards and only towards a deprivation of liberty. In that situation, says the Court of Appeal, subject to de Wilde, the question of whether or not the subject of an application to authorise the deprivation of liberty of a young person under the inherent jurisdiction is in agreement with the proposed regime may form part of an evaluation of whether such authorisation is necessary. So assuming that such an application would be determined under the inherent jurisdiction, the judgment of the Court of Appeal is, therefore, that consent would be relevant in considering the welfare best interests of the subject child. So there are to be two types of decisions under the inherent jurisdiction, both applying the child's welfare as paramount, but one disregarding the issue of consent. In our submission, children's wishes and feelings, including consent, play a very important role, both in our domestic law and in international law. Consent must always be relevant when considering the paramountcy of a child's welfare and indeed the need to act proportionately. A child cannot become a looked after child without their wishes and feelings being considered. If the threshold prior to making a care order are established under Section 31 of the Children Act, a court may not make such an order without first deciding it's in the child's best interest by applying Section 1 criteria, which includes having regard to the ascertainable wishes and feelings of the child concerned, considered in the light of his age and understanding, Section 1(3)(a) of the Act. If the local authority contemplates the accommodation of a child pursuant to Section 20, it must, before accommodating her, ascertain the child's wishes and feelings regarding the provision of accommodation as far as is reasonably practicable. That's Section 26(a), and give due consideration to such wishes and feelings, having regard to the child's age and understanding. Once a child is looked after, and here, if I may, I'll look at the English scheme. Once a child is looked after, Section 22(4) obliges a local authority to ascertain the wishes and feelings of the accommodated child before making a decision about that child. Section 22(5) obliges the authority to give due consideration to those views in making a decision with respect to such a child, having regard to his age and understanding. And so the consent of a GILIC competent child must weigh heavily on the local authority's decision making as part of the overall obligation on the local authority to safeguard and promote the child's welfare. If an order is made pursuant to section 25, then the wishes and feelings of the child must be ascertained, if practical, and taken into account under Regulation 15 of the 1991 regulations during the review, which must be undertaken within a month of the provision of secure accommodation and every month thereafter. Every 6 months thereafter. Sorry, every 3 months thereafter, forgive me. Yes, the orders that are made every 6 months, but the review is every 3 months thereafter. The statutory guidance to local authorities as to their functions and responsibilities under Part 3 of the Children Act, there at 2588, highlight the significance of and the need to engage children as active participants in the making of decisions about them. And in particular, paragraph 111, which is 2589, children should feel that they are active participants, engaged in the process when adults are trying to solve problems and make decisions about them. When plans have been made for the child's future, she or he is likely to feel less fearful if she or he understands what's happening and has been listened to from the beginning. Close involvement will make it more likely that he or she will feel some ownership of what's happening to help them understand the purpose of services or other support being provided. Where a child has difficulty in expressing their views or feelings about any decisions made, then thought should be given to the support by way of an advocate. And there are further practical reasons for ascertaining a child's wishes and feelings during the care planning, placement and review process. Most obviously, of course, in a case where a child may be absconding, their wishes and feelings will be particularly important. But many children have an understanding of what is causing their problems and what underlies their needs. In this case, it's the appellant's firm position that she appreciated the deficiencies in the parenting that she had received and the need to make progress. And she saw as part of that her need to work with the organisation where she was staying to make that progress. And part of that for her was the importance of being able to consent and have her consent accepted as valuable and indeed valid. The child may have insight into what may or may not be working, and they may have an idea about the sort of support they should be accessing. And we would suggest that engaging children helps to recognise their difficulties, develop their strengths and promote their resilience. So before becoming a looked after child and throughout that period, the child's wishes and feelings must be ascertained and given due consideration. The older and the greater the child's maturity, the more weight those wishes and feelings will have. And that, of course, accords with the UN Convention on the Rights of the Child, and particularly Article 12. In this case, we've set out in our written case, at paragraph 90, that there was no suggestion that the consent she gave was invalid for want of understanding the consequences of what was involved. There was no issue about her ability to understand and make decisions. There was no issue that she gave her consent. The question simply was whether the consent she gave was sufficient in terms of Article 5. It was said on behalf of the appellant, and this is at page 740 to 743, that in her witness statement, it was an important expression of her autonomy that she should be able to consent to the arrangements proposed for her, and a significant benefit to her for that autonomy to be recognised and her consent to be given due weight. May I briefly mention the question of jurisdiction, as it took up a significant amount of time in the court below. To the extent the court is interested, we have set out at paragraph 93 in our written case, which is electronic page 203, in short order, the history of the development of this point. The court will see that on behalf of the appellant at first instance, it was said the appellant's consent meant there was no need for an order. It was not said there was no jurisdiction to make an order. The orders recite the understanding that whilst the appellant consented, such that it would be unnecessary to make a Dole's declaration, It's acknowledged that the extempore judgments, whose transcripts were received some time after the applications were put in for permission to appeal, do not align neatly with the carefully drafted and agreed and approved orders, nor with the written submissions. And then Junior Mr. Leng is content for me to say on his behalf that with the benefit of hindsight, he should perhaps have asked the judge to clarify or correct that dissonance. Equally, one of the other parties might have done so. It's the appellant's case that the Court of Appeal misapprehended that position at first instance when it says that paragraph 83, he, the learned judge, was unfortunately drawn into a legally erroneous position by accepting it was necessary for the court to find a lack of valid consent before it could grant the local authority's application. It went on to refer to this as a non-existent jurisdictional requirement, all of which contributed to the fact that the decision of the Court of Appeal is not really a lady.
I just want to be sure. This point about jurisdiction, the absence of consent as a precursor to the court getting involved, just doesn't, we don't have to be concerned with it, do we?
No. No.
So do we need to go through this?
No, probably not.
It's there in your written case very clearly, and I can see that there are sensitivities about it. But if it doesn't actually arise as part of the legal issues, we might be better spending our time on the things that do.
My lady, I'm very grateful. The position, therefore, is how the Court of Appeal addressed the arguments the court is concerned with. Let me see. We're having addressed then. So I think I'm looking now at paragraph 79 of the appeal judgment at 408.
Are we at paragraph 94 of your written case, in fact?
Yes, yes, indeed we are.
Yeah.
And we refer in particular to the court's powers in section 25 are said to be directly applicable to this case. Those cases where the inherent jurisdiction is used to authorise the so-called equivalent of secure accommodation. And the Court of Appeal repeats its assertion that the existence or absence of consent may be relevant, whether the circumstances will or will not amount to deprivation of liberty. And this ultimately then leads to the court making clear in 84 that consent may form part of the evaluation in cases other than this type of case that they have labelled as other than the equivalent of secure accommodation. So having indicated at 81 that consent was irrelevant to the scope of the court's powers, the conclusion removes consent from the evaluation under its powers in the equivalent of secure accommodation cases. So that move from its position at 81 to 84 is, we submit, a move too far. That we say it's simply wrong and that consent is relevant in the exercise of the jurisdiction and the evaluation of the judge hearing an application under the inherent jurisdiction. And we agree with the recitals that are set out by Mr. Justice Mostyn on his orders that where child consent is not necessary to make the orders. The challenge to the first instance decision was about the quality of the consent required. The Court of Appeal has, we say, developed the common law to say that consent is irrelevant. It's that development of the common law we now invite this court to correct. Of course, we do not invite the court then to remit the proceedings to consider how the appellant's consent in this case should impact on the evaluations of the order made. Not only is the appellant now 18, but the orders have been discharged. My ladies, my lords, those, subject to any other assistance I can provide to the court, are the submissions I seek to make.
Thank you very much indeed, Mr. Toomey. I'm just waiting to see if anybody's got any particular questions that arise from your submissions. No, it doesn't look like it. So thank you very much indeed, and to those who I've heard assisting you as well. Ms. Clement, I think you are next to make your submissions, aren't you? Would you like to do that now, or would you like to start at 2 o'clock?
My lady, I think I prefer to start at 2.
No, thank you very much indeed. That's what we'll do then. We get an extra 6 minutes.